Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today's webinar is what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the incredible Rick Sissman.
Good morning, everyone. This is Rick Sissman. I practice in Maryland, DC, and Virginia, helping subcontractors and material suppliers and a few prime contractors to collect upon their mechanics liens and what needs to be done. Ariella, if you'd like to turn to the first page. Everyone, is that we're dealing with Maryland today, is my understanding. And for those of you who have had the opportunity to proceed on a mechanics lien in the state of Maryland, as you should know, is that your first step is to file your notice of lien if you did not have contractual privity directly with that of the owner. In Maryland, there are two types. The owner is defined in two ways. It can either be that of a tenant, which is considered an owner under Maryland lien law, or that of the landlord. So you must make a determination. If you did not have privity of contract directly with the tenant or the owner, you need to find out as a subcontractor whether or not you've had who is considered the owner of the property. Now, in my practice that I always place in my notice of intention to lien letter, I always add the owner, the landlord, and the tenant if there's a tenancy involved. Say you're doing a build out of a restaurant. The reason I do that is that you want to make sure that the owner / landlord is placed on notice that there's a potentiality of you coming after the leasehold interest. What will that do? That will spring into action the owner / landlord to contact his tenant, which would be a breach of the lease, to see what is ongoing. Now, most of the time on these build outs, the landlord is aware of what is ongoing with the construction or the build out of that tenancy space. And sometimes there's a build out allowance. And if there is a build out allowance, then in fact you can probably bring in the landlord, which would be deemed a necessary party, which would go to your next stage is on the petition to enforce the lien. Now, as you see on screen, step 1, your petition to establish must be filed within 180 days of your last day of work. That last day of work means your last day of work and not the last day of work, say, of another sub or supplier or that of a prime contractor, which is contrary to District of Columbia lien law, where the lien statute says at completion of the project. But Maryland requires that you must file your petition, which is a lawsuit filed in the circuit court of the county in Maryland where your real property is located. So going a step forward, on the petition to establish, once you must do this within 180 days. Now, once the lawsuit is filed, you must bring in all necessary parties. Necessary parties are deemed, in my opinion, any other parties that you believe that may have filed another notice of intention to lien letter. Although not necessary, I always bring in that as a necessary party. As I indicated, I would bring in, if it's a tenancy build out, I still would bring in the landlord in the lawsuit as a necessary party, because you're actually going after the real estate. Technically, it's called an in rem, which is INREM action. So you're pursuing the real estate. You're not really suing a contractual breach. But in most of my petitions to establish, I will always have several counts, one of which would be the petition to establish and enforce a mechanics lien, which would be the caption of your case, along with a breach of contract action if you're working for the prime or for your first tier, or if even you're a second tier, which is allowed. So a second tier a supplier or subcontractor is permitted to pursue a lien. My recollection is that a third tier is most probably precluded from pursuing a mechanics lien action in a petition to establish. Your attorney would know that in your petition, you must say petition to a petition to determine a mechanics lien along with enforcement. And the reason you put that language in there is that this must be concluded within 1 year of the date of filing of your petition. So there is basically an expedited basis, as you can see on your show cause hearing, step number 2. What happens is that once you get your petition to establish filed with the court will issue a summons to all the parties that you have filed suit against. You then will also have a show cause order that you have drafted and provided in the filing, and that show cause hearing must be held within 45 days of when the petition is filed. Normally, based on today's standards and during COVID, of course, that time frame can be extended past the 45 days. The purpose of the show cause hearing is to determine whether or not you have made a probable cause determination that you are entitled to what's either called an interlocutory lien or a final lien. As noted on the screen before you, there will be a show cause hearing, which is a truncated hearing, which usually lasts about a half hour. That hearing should be set, as I said, within 45 days of the filing of the petition, but by consent, you can get an extension of time. What happens at this show cause hearing? You must bring your witness who has knowledge as to what labor and materials were provided to the project. It's a lower standard than most other hearings. It's basically, I would say, below that of a civil proceeding. It would be that of probable cause, more likely than less you have made your determination. A little bit less than a preponderance of the evidence, which is the standard in a civil proceeding. Now, if the court believes you've met that threshold, and in most cases you should be able to make that threshold, the court will grant what's called an interlocutory lien. What is the advantage of an interlocutory lien? It gives you the ability to cloud title on that property. So if that tenancy or that building was going to be sold, you would encumber that property so that the building would not be sold. And I believe the tenancy, if you're going after the tenancy, that would be a material breach of the lease between the owner/landlord and that of the tenant. Now, also, if you don't make that threshold, then the court would deny the petition. However, there is a rule under the Maryland rules, under the 12 section, Title 12, that says even if you don't make that threshold, and your attorney should know this, is that within 30 days of the denial of the interlocutory lien, you can make a motion for a final hearing to get a determination of a final hearing of whether you're entitled to a final lien. Now, if your interlocutory lien is granted, the court must have a final hearing within 6 months of that determination of your show cause hearing. So the interlocutory lien will be recorded and is of record. Now, when we get to the next stage, if you'd like to go to step 3 on the slide. Well, as I said, I mentioned that if your petition is dismissed, you do have 30 days to make a written demand. We've discussed that already. So if you'd like to go to the next screen. Now, suppose that you go to a final hearing. Now, let me just backtrack a second. It is possible on occasion that the court would determine that, especially if you're a supplier, there's really no issue of fact, that basically you're entitled to a final lien, or at the final hearing that you get your final lien, you are then entitled to force the sale of the property within that 1-year time frame. And if I step back a second, I mentioned that in your original petition, you always should put in the language and enforcement of the lien in your original filing. What does that do? That could extend your 1-year time frame should that be necessary in order to sell the property. But in most instances, and in all the years I've been doing this, I've never had to go to the stage of actually having to sell the property. Now, a bond would be required to be posted by you. That would be set by the court. And depending on the valuation of the property, that bond could be the value of your lien plus other additional costs, which could be fairly expensive. You could either do a cash bond, which most of the contractors that I represent would not be able to afford that. So what you would do is you would go to a surety, and the surety would be able to post that bond for you. Also, in the interim, the owner or / tenant, well, I should say mainly the landlord, if there is an interlocutory lien or any form of lien placed upon the property, they're also able to bond off the lien, which means there'll be a pot of money sitting in the court's registry, or if you determine to hold it in a separate escrow account. So after the final hearing is determined and held and you're successful, there'll be a pot of money for you to proceed against. Now, in the event that it's not bonded off and you have received your final lien, a trustee would be appointed to commence the foreclosure proceeding, and then the trustee, of course, would get paid from the proceeds of the sale. But as I indicated before, I've never heard of it having to go that far, and I've never had that experience of having to actually go to a foreclosure sale based upon a petition. Now, quite frankly, you do not prime anyone above you, especially that of a lender. So if there's a lender on the property who has encumbered the property, of course, with a deed of trust, you take subject to that of anyone that has recorded and perfected their lien before you. So it's conceivable that there may not be enough equity in the property to go forward with the foreclosure, because you in turn would have to pay off anyone that is over and above you. And as you know, on some of these properties, you're talking about millions of dollars of loans on these buildings. And it is conceivable sometimes that a lender may step in, depending on the size of your lien, and actually pay off that lien and then deal with the owner concerning that issue of the lien that it has paid off. It would step in and probably look for indemnification from that of the owner. But that is a very rare instance, as I've indicated previously. If you'd like to the next step. Just very briefly, I can mention to you, if you're in your contract, if you have an arbitration clause, sometimes that in and of itself can be detrimental to you. And Maryland courts must stay the mechanics lien proceeding if arbitration is requested by one of the parties and the construction contract has an enforceable arbitration clause. Now, in order to establish the lien, the court would have to hold a hearing to determine the status of the accounts between the parties. To do this, the court would review all of the evidence which would violate the arbitration provisions. Normally, the court, and you would insist, is at least to protect your interest, even if there is an arbitration clause in your contract, you would say to the court to go forward and at least try to get an interlocutory lien, which would cloud title. And in the interim, once that interlocutory lien has been recorded, You would then go to arbitration and work out whatever that would be on your contractual provisions. And then if you're successful in the arbitration, you would then go back to the court, and I would say the stay would be lifted to allow you to proceed with your lien. Most courts, in my experience, would allow you at least to go forward and try to get an interlocutory lien, and then you would go, the case would be stayed and go to arbitration, and the outcome of that arbitration would determine whether or not you can pursue your mechanic's lien to the final stages. If there are any questions, Ariella, if anyone has any questions, they could let me know.
So far, we do not have any questions. However, if anyone has a question after this webinar that you think of, please feel free to send us an email. I think that was extremely thorough and very helpful to our audience. Rick, I want to thank you so very much. And we'll go to our next slide to share with everyone, which is we have 2 more webinars for this year for Maryland. Don't sign a release unless it says this one thing, and getting paid faster with liens, bonds, and contracts. So you could sign up at sunraynotice.com/education. And with that, again, Rick, a wonderful job. Thank you so very much.
Yes, thank you, and everyone have a great day.